Florida's Senate Bill 264 was designed to block Chinese nationals from buying property near military bases and critical infrastructure. The 11th Circuit just ruled it cannot reach the ones already living there. That gap between what the law says and who it actually catches is where this starts. Governor Ron DeSantis signed Senate Bill 264 on May 8, 2023, with an effective date of July 1st that same year. The law bars citizens of China, Russia, Iran, North Korea, Cuba, Venezuela, and Syria from purchasing farmland or any property within 10 miles of a military installation or critical infrastructure. For Chinese nationals, the restriction extends further. No Florida property at all, unless you hold a visa, in which case you may own one home with mandatory registration filed with the state. The law is codified under Florida Statutes Chapter 692. At signing, DeSantis framed it in direct terms, stating that airports, power plants, telecom systems, and other critical infrastructure would not be compromised by adversarial foreign governments or their nationals. Supporters of the law argued that the federal government had been failing to adequately protect states from potential threats posed by foreign ownership near sensitive sites. Critics pushed back hard on that framing. Ashley Gorski, an attorney with the ACLU National Security Project, who led the legal challenge in the case known as Shen versus Simpson, put the objection plainly. There is no evidence in the record of any nexus between Chinese home ownership and harm to national security. The evidence just isn't there. Which brings us to what the records actually show. According to the 2024 USDA AFIDA annual report, covering data through December 31, 2024, Chinese businesses and citizens hold approximately 0.018% of all privately held agricultural land in the United States, roughly 1 out of every 5,600 acres, and 0.5% of all privately held foreign-owned agricultural land in the country. Canadian investors, by comparison, hold the largest share of foreign-held agricultural land at 34%, or 16.1 million acres. One thing to flag about those AFIDA totals: they include long-term leases and partial ownership stakes, not solely deeded outright ownership, so the figures measure reported interest rather than a clean count of who holds title. And that already small share has been shrinking. The 2024 AFIDA data shows Chinese-held agricultural acreage dropped by approximately 30,000 acres in the most recent reporting period, a decline of around 14% from 2023. Here is where the numbers start pulling in opposite directions. While Chinese ownership of American farmland amounts to a fraction of the national total, Chinese buyers of American residential property came back strongly in the 2024 to 2025 period. According to a National Association of Realtors report published in July 2025, covering April 2024 through March 2025, Chinese buyers collectively spent $13.7 billion on American homes, an 83% jump from the year before, amounting to roughly 11,700 individual home purchases. These are tens of thousands of separate transactions by separate people, not a single entity, not a single fund. And that distinction matters for understanding what the data actually captures. The average purchase price came in at approximately $1.16 million, more than double the national median. The top destination for those buyers was California, which absorbed 36% of all Chinese residential purchases in the United States during that period. California has not passed anything comparable to Florida's law. Senate Bill 224 prohibits a foreign government, not individual citizens, from purchasing or holding a controlling interest in California agricultural land. A separate bill, Senate Bill 1176, introduced by Senator Stephen Choi, would extend restrictions to businesses or governments from countries designated as national security threats. But its operative date sits at January 1, 2027, subject to legislative appropriation, and as of this research, it has not become law. Set that against Florida's approach, and the contrast sharpens considerably. But the 11th Circuit's November 2025 ruling which allowed Senate Bill 264 to remain in force, contained a finding that reframes the practical reach of the whole thing. The majority opinion, authored by Circuit Judge Robert Luck, clarified that Chinese citizens with long-term Florida residence and an intent to stay are legally domiciled in Florida, not China, and the law, by its own terms, does not reach them. Step back from the headline restriction and consider what that means for enforcement. The people who made Florida their permanent home, who built equity there and put down roots, fall entirely outside the law's scope. The law catches the short-term visitor, the recent arrival, the new immigrant without permanent status. Whether those are the intended targets depends entirely on who you ask, and the gap between the two answers explains why this debate has not settled. The federal government weighed in against the law while litigation was still active. The Department of Justice's June 2023 Statement of Interest argued that Senate Bill 264's provisions would cause serious harm to people on the basis of national origin, contravene federal civil rights law, and would not advance the state's stated safety goals. Critics also noted the tension with the existing federal framework. The Committee on Foreign Investment in the United States, known as CFIUS, already operates under the Foreign Investment Risk Review Modernization Act to screen transactions involving foreign entities near sensitive national security sites. The argument from the federal side was that state-level restrictions risk fragmenting a review process that was designed to function at the national level. The 11th Circuit never fully resolved the constitutional merits before the plaintiffs voluntarily dismissed their claims and closed the case. Across the country, the legislative pace has accelerated. According to the Committee on 100, a nonprofit tracking foreign property ownership legislation, 26 states have passed 63 bills restricting foreign property ownership, with 11 becoming law in 2026 alone. In July 2025, the USDA Secretary Brooke Rollins launched the National Farm Security Action Plan, pledging expanded AFIDA enforcement and broader review authority over farmland transactions involving entities from countries of concern. There is an older layer to this story that rarely surfaces in current coverage. California was among the first states to enact alien land laws, back in 1913, explicitly barring Asians from owning agricultural land. Those laws held until the Supreme Court addressed them in Oyama v. California in 1948, a ruling that gutted their enforceability, and California did not fully repeal them until 1956. The legal architecture being assembled today, state by state, is new in its specific targets and mechanisms, but the underlying shape of the argument that foreign nationals of a particular origin pose a distinct property ownership risk has appeared in American law before. Whether today's restrictions represent a legitimate national security tool or a repetition of a familiar historical pattern is a question courts, legislators, and voters are still actively working through. What the ownership data does settle is this: Chinese nationals hold a small and declining share of American agricultural land, while Chinese buyers, as an aggregate of many separate individuals, are spending more on American residential property than at any point in recent years. Florida drew a legal line. California has not drawn the same one. And the ruling that allowed Florida's law to stand also explained, in careful legal language, why its actual reach is narrower than the headline version of the law suggests. Tracking the gap between what a law says about who can hold property and what the records show about who actually does is the work this channel covers. The next record is already open.